Sure. So my name is Daniel Gvertz. I'm an attorney here with Tully Rinckey. I'm one of the partners in the family and matrimonial practice group. I've been practicing for just over 15 years, specializing in divorces and custody and support cases. Jillian is one of our associates here. She is doing excellent work, and we are going to be presenting today on, how we can help with uncontested divorces and when they might work for you.
Okay, so we could begin with the general overview. An uncontested divorce is a legal procedure where both parties reach an agreement on all dimensions of the divorce without resorting to litigation. Even with an uncontested divorce, one spouse will be identified on the forms as the plaintiff, while the other spouse will be identified as the defendant.
Courts are inherently an adversarial place, and even in the instance of, a full agreement, the procedure still calls for a plaintiff and a defendant, but that doesn't mean anything when it comes to what your agreements are. Neither is gaining any sort of advantage there. Thank you.
And then touching on the advantages of an uncontested divorce. First, generally, an uncontested divorce requires less time than a contested divorce due to the absence of prolonged court proceedings. Secondly, uncontested divorces tend to be more cost-effective, saving legal fees for both parties in the long run. And then establishing the grounds for divorce. Most uncontested divorces proceed under the no-fault ground, Domestic Relations Law 170, Section 7, which states that the marriage has been irretrievably broken down for at least 6 months. This means that neither spouse is required to prove wrongdoing. Using the no-fault ground simplifies the process since there is no need to present evidence or argue over fault. Mutual agreement on divorce terms. Prior to filing the divorce, the parties need not have agreed on all terms of their settlement. Oh, we're on the wrong side. Meeting the residency requirements first. Before filing for divorce in New York, at least one spouse must meet the residency requirement, which means that either spouse has lived in New York continuously for at least 2 years before filing for divorce. Both spouses have lived in New York for at least 1 year and the marriage took place in New York, or the grounds for divorce happened in New York, or both spouses currently reside in New York and the grounds for divorce occurred in the state. Or if the residency requirements are not met, the court will not accept the divorce filing.
They need to have agreed. In order to have an uncontested divorce, a fully uncontested divorce, you do need to agree to everything beforehand. And it is one of those things where, there are, we're not ignorant to the fact that this is a relationship, right? There are a lot of moving parts and a lot of things that need to be discussed that are not easy to discuss. And that's why, a fully uncontested divorce may not be for everybody, but we do need to make sure that all of the terms of the divorce are agreed on before you go ahead and file, or else the procedure might take a bit longer than you were expecting.
And expanding on the marital settlement agreement, you and your spouse will need to work out agreements on all of the issues in your case, including how to divide real estate and personal property from the marriage, how to allocate outstanding debts, whether either spouse will pay maintenance or alimony, and if so, how much, child support for any dependent children of the marriage, and issues of custody and visitation. The settlement agreement. A marital separation agreement may be drawn before or after you have filed for divorce, even while you and your spouse are still living together. And the effects of domestic violence in an uncontested divorce. An uncontested divorce is generally not advisable in cases where there's a history of domestic violence or a significant power imbalance between the spouses. If one party feels unsafe or under pressure to reach an agreement, a contested divorce may be more appropriate to ensure that all terms are discussed in a safe and balanced environment.
And when it comes to things like this, it's always I mean, it's a very personal decision to make, but there's no requirement. People always ask me, does my does my spouse have to talk to me about settling our divorce? And there's no requirement that either of you speaks to the other one, right? You can have a lawyer, you can talk to each other through your lawyers. It If you are able to, what I always tell people is, if you are able to have the discussion, then you should, right? As long as you're able to discuss things, make sure that you do it. But as soon as it becomes uncomfortable, as soon as it becomes something that you feel like you're being forced to do, then you can stop the discussion and go ahead and use the court system for what it's there for, which is, you have an advocate on your side, you have a counselor on your side, making sure that your rights are protected. And there's no fault in that, and there's no losing anything with regard to that. And on the flip side, just because you use an attorney, just because you go through the contested rather than uncontested divorce process, doesn't mean you have to take things that you otherwise were okay giving up. You don't have to take spousal maintenance if you didn't think that you needed it. It's just, we have to make sure that you're aware that it's an option for you. So when we comes to issues of domestic violence and it comes to issues of a power imbalance, those are obviously deeply personal things, but you have to make sure that you are not proceeding in a direction that is uncomfortable for you.
And then moving on to commencing the action. Filing an action for divorce begins by submitting a summons and complaint to the county clerk and paying the filing fee. The complaint will state all the marital issues have been resolved by an agreement and will attach a copy of that agreement for the court. Since an agreement is already reached, the work for the court is already done. Since this agreement avoids the need for a court appearance, the divorce can be processed on affirmations of the parties only. And even in an uncontested divorce, some challenges may arise. There can be incomplete paperwork with errors or missing documents, which can delay the process. There can also be disagreement on settlement terms, and when disputes arise, mediation may be necessary. There can also be service issues, and when the defendant cannot be located, special permission is required for alternative service methods. The divorce judgment. If approved, the judge will sign the divorce judgment, officially finalizing the divorce. You will need to provide a copy of this judgment to your ex-spouse. And post-divorce, updating legal and financial documents. Once the divorce is finalized, both spouses should update their legal and financial documents, including any applicable name changes, bank accounts and credit cards, insurance policies, and then also focus on estate planning. The role of a matrimonial law attorney. Although an uncontested divorce may be simpler than a contested divorce, seeking legal advice can help ensure all agreements are fair and legally sound. And to schedule an initial consultation, we have our contact information contained within this slide.
So as you can see, this was a shorter presentation, because an uncontested divorce really means that the two of you are able to work out all of the issues that may come up that other people might be fighting about. But there's always a role for an attorney to play in these kinds of things. And I always advise people, even if you and your spouse are able to agree on absolutely everything, it benefits you to, at a minimum, have an attorney read through your settlement agreement just to make sure it says the things that you believe it to say. I've had no shortage of cases where, for example, people will agree to a custody and visitation schedule that includes something along the lines of alternate weekends, but then one party thought that the weekend started on Friday and one party thought the weekend started on Saturday. Or we say, the third weekend of every month. Well, it just so happens this very weekend, October of 2025, Friday is in October, Saturday and Sunday are in November. Is this the final weekend of October? Is it the first weekend of November? There are always questions like that attorneys are trained to look at and answer that, your average person just doesn't think that might be an issue. So there are always hairs to split and things like that. And then beyond all of that, it's important to know what you give up when you give it up. When there are, retirement accounts, pensions, and things like that to be divided in a marriage, you might agree that maybe you shouldn't have access to these things, but if you do, you need to be aware that you are giving that up. Not only because it's important to make informed decisions, but because a court might reject your whole filing if you don't indicate somewhere that you're aware that you're giving things up that you otherwise had a right to. And then that throws a wrench in all of your filings and causes everything to drag on. So it's important to, even if you and your spouse are able to come to full agreement on all of the terms, it's important to send over that agreement to an attorney to review it in order to make sure, one, that it says everything that you expected it to say, and two, that it actually covers all of the important terms that need to be covered. The last thing you want is to finalize your divorce today and then find out in 5 years that a life insurance policy was supposed to have a beneficiary change and it never did. And now you're, 5 years later and trying to recreate the circumstances of your negotiations 5 years ago. It's just not something that's really palatable or something that you want to go through when you already felt like you've moved on with your life. So there are a number of ways that we can help in terms of an uncontested divorce. And just because you hire an attorney doesn't mean that you're fighting terms. It doesn't mean that you're disagreeing to things that you otherwise would have agreed to. It's not the role of your attorney to pick a fight where you didn't want to pick a fight. It's the role of your attorney to counsel and advocate for you. If you want to have something be completely amicable, then your attorney can do that for you. And that's something that we can do here at Tully Rinckey. Thank you.